Good morning, everyone. Welcome to a New Hampshire Business Review webinar. I'm Ernesto Burden, publisher of New Hampshire Business Review, and it's my pleasure to introduce today Solar in New Hampshire, Clearing the Path for Development. This webinar is sponsored by McLane Middleton, and today you will be hearing from Barry Needleman, Director, Administrative Law Department and Managing Director of the Concord office at McLane Middleton, Rebecca Walkley, Counsel, Administrative Law Department of McLane Middleton, and Viggo Fish, Counsel, Administrative Law Department, McLane Middleton. We will be hearing from each of them individually, and then we'll all be getting together for a Q&A. If you have any questions, remember that you can type them into the Q&A module here on the webinar platform, and we'll keep an eye out for them, and we'll answer all of the questions at the end of the presentations. So please do put your questions into the chat, and with that, we'd like to invite Barry to take the stage.
Thanks, Ernesto. Good morning, everybody. It's nice to be here. We appreciate you joining us today. As Ernesto mentioned, you'll hear from three of us this morning. All three of us practice here at McLane in our energy and environmental group and have a wide range of experience dealing with energy projects here in New Hampshire, including solar. I'm going to start us off this morning with a brief description of the paths that one can follow to permit a solar project here in New Hampshire. And broadly speaking, there are two paths. You can either permit locally or through the state site evaluation committee. It is really a function of the size of the facility that you're seeking to permit. If the facility is over 30 megawatts, then it automatically goes to the site evaluation committee. If it's under 30 megawatts, then it's discretionary. The site evaluation committee may have jurisdiction, it may not, and I'll explain a little bit more about that shortly. The fact is that the vast majority of solar permitting here in New Hampshire has been at the local level, not at the site evaluation committee. And so for that reason, our presentation will only briefly touch on this SEC path. I'll cover that this morning first, and then Rebecca and Viggo will go into more depth on local permitting and the various issues surrounding that, including talking about some things that overlap between the site evaluation committee and local permitting. When one thinks about the site evaluation committee, for those unfamiliar, the best way to think about it is that it's really a super land use board that was created by the New Hampshire legislature to review large energy projects, those projects that are deemed to be of statewide importance, where both the impacts and the benefits are beyond just the host communities for the project. The site evaluation committee was recently reconfigured by the legislature, and so now there are 5 members, the 3 PUC commissioners, the commissioner of the Department of Environmental Services, and 1 public member. It's also important to understand that the site evaluation committee supersedes any local permitting. And I know that, for example, we have a range of folks on here from towns around the state. Regardless of what your perspective might be on the permitting of a facility at the site evaluation committee, though, understanding that all local permitting is essentially set aside, and that the entire facility and the project is permitted through the site evaluation committee. That being said, the site evaluation committee is sensitive to town concerns, and there is certainly an expectation in all our experience taking projects through there that the developers will work closely with those host communities and be mindful of their concerns. And of course, that doesn't mean host communities can't participate in the process. They can. They're permitted to intervene in that process, and their intervention is typically welcomed by the site evaluation committee. In terms of activity that has happened there for solar projects, there's only been one. It was a project called Chinook Solar. It was permitted in Fitzwilliam. It was a 30 megawatt project, 513 acres covered. It was approved in December of 2020, but then subsequently the project proponents chose not to build the project. And so there are no solar projects in the state today over that 30 megawatt threshold. I will say that I'm familiar with a fair bit of activity out there in the solar arena as it relates to these larger projects. And I think it is reasonable to expect that at some point in the coming years, we will see some of those larger utility scale projects come to the site evaluation committee. I mentioned earlier that if the project is below 30 megawatts, it can still end up at the site evaluation committee. That's referred to as discretionary jurisdiction. Sometimes that happens because a developer asks the committee to take jurisdiction. Sometimes it happens because a town makes that request. In either circumstance, the committee doesn't have to take jurisdiction. It's up to them whether they do or don't. An example of a developer making that kind of request was the Antrim Wind Project, and the committee did take jurisdiction. More recently, there was an example where the towns of Bethlehem and Easton asked the site evaluation committee to assume jurisdiction of an Eversource transmission line project. And that was just decided last month, and the committee did choose to take jurisdiction. There have also been circumstances where both towns and developers have requested that the SEC take jurisdiction, and it declined. In either case, parties may have good reasons for why they want the SEC to take jurisdiction. If you are a town, for example, and you're confronted with a large solar project, you may feel like you don't have the bandwidth or the expertise in your community to assess that project. And so you might want the SEC to look at it instead. Conversely, if there's a developer in town who has a large solar project and they want it to go to the SEC, and the town doesn't, the town may feel that they're capable of handling it, and they may want to keep control over it and not give up that local permitting perspective. So it really varies a fair bit. If you're a developer, you may have the same perspective. You may have a good relationship with the town. You may prefer that the project stay local. Or conversely, you might have good reasons for trying to take the project to the SEC. You might want to avoid the risk of multiple appeal paths. You might think the SEC could be more efficient. So as you can see, there are a lot of variables associated with whether discretionary projects end up at the SEC from the town or the developer perspective. It really ends up being very much a case-by-case analysis, and one that depends highly on the facts of the project, the capabilities of the host community, and ultimately, to some respect, the preferences of the developers and the host communities. In either case, state agency permits need to be obtained, and that's one thing that Rebecca and Viggo will talk more about, but that's that area of overlap I was talking about a moment ago. Regardless of whether you are at the SEC, which is frequently thought of as a one-stop shopping approach where all that state permitting is integrated, or you're at a local level, you are going to have to get some of those various state permits like wetlands, alteration of terrain, things like that. And then the last point I will make about this, as we are working with developers and advising them about these various permit paths, we always say to them that you shouldn't ultimately make a selection based on where you want the jurisdiction to be, either with the town or the SEC. That selection is really best made based on the economics of the project, the land that's available, the impacts that you expect, the relationship with the host community, things like that. The permitting path should be a factor in that assessment, but it certainly shouldn't be a deciding factor. So with that said, I know there'll be some opportunities for questions at the end, but I'm going to hand it off to Rebecca now. Rebecca?
Good morning. I appreciate the opportunity to speak with you all this morning. And as Barry mentioned, I'm going to be speaking on the topics of the local permitting process for solar projects, as well as a discussion on some DES related permitting issues specifically focused on the wetlands permitting process. So first on the local review process, in the last 5 years or so, there's been sort of an uptick in the number of municipalities that have adopted solar-specific ordinances. I think at last count in 2023, there was about 72 towns that had adopted ordinances, which is roughly a third of the towns in New Hampshire. What you'll see with the ordinances that have been adopted is that many of them are similar. Clean Energy New Hampshire issued a model solar ordinance in 2018, and many of the municipalities that have adopted ordinances have used that model solar ordinance as a framework. So you'll see a lot of overlap. With respect to whether or not a town has adopted a solar specific ordinance, I think it cuts both ways. Doesn't necessarily reflect whether or not the town is attempting to promote solar, or maybe they're trying to adopt regulations that make it more challenging for developers to construct solar in the municipality. So there's sort of different motivations for the adoption of solar ordinances. Whether an ordinance for solar specifically has been adopted by a town, the practical reality is that usually that's used as an overlay framework, and a potential solar project will still be subject to site plan review process and zoning requirements. And what we've found in working with developers on local review process is that you kind of have a square peg round hole issue with respect to planning regulations and zoning regulations. Because they really weren't set up and adopted with solar projects specifically in mind, particularly in the context of the pieces of the solar projects that really aren't contemplated by these regulations, is the fact that these projects span numerous parcels for the most part. They involve construction of non-residential structures and often involve lease rights as opposed to outright ownership rights. So just as sort of a practical example of where we've seen this become an issue for developers, and just the difference between how developers may be thinking about a solar project as opposed to how the planning and zoning bodies may seek to enforce their regulations. We had a client who was looking to develop a project across multiple leased parcels, and the developer's view was that they were looking at the totality of the project site as opposed to consideration of the property lines that cross through that, that overall property site. So we had received numerous approvals from the town, and sort of at the 11th hour during the site plan review process, it came up that the project site didn't comply with the setback requirements between each of those individual parcels. So again, this just shows sort of the difference in terms of how towns will be reviewing this at sort of a more reading their ordinances and requirements literally, as opposed to a developer that may be thinking about the practical effect of whether or not those ordinances really should apply to a project like a solar project. And so there's a little bit of a rub there. And in our case, it didn't end up being a big deal. We filed for a variance and received that approval from the town because obviously, you know, there was no issue there in terms of an actual effect on an abutting property owner, where we were kind of the holder of all the rights within that larger site area. But I think that the practical takeaway from that is that it's really important to have upfront conversations with the municipality you're working with to try to make sure you can flag those issues as early as you can and understand what it is you're really going to need from the municipality, so you don't end up in a circumstance where we were trying to, you know, last minute get together a variance application, and we could have kind of proactively done that. I did want to flag just a couple of useful legal pieces that seem to promote the development of solar at the local level. One of them being RSA 672(1), which talks about the development of solar being something that should be included in local regulations, and specifically notes that renewable energy shall not be unreasonably limited by use of municipal zoning powers. And sort of coming out of that, the other legal piece I just wanted to flag that I think is useful to know about is that in 2024, pretty much a year ago now, the New Hampshire Supreme Court issued a ruling on the name of the case is the Mojalaki Holdings LLC versus City of Franklin. And that case involved a 1 megawatt solar project in Franklin. And in its ruling, the court said basically that a planning board cannot deny projects that comply with all the technical requirements of an ordinance based on, and this is the court's words, its own personal feelings. And I think the takeaway from that case is that, you know, planning board review is fairly limited in terms of the scope, and you really have to work within the framework that exists within the regulations. And the court specifically noted that a project can't be denied simply because the planning board doesn't feel the proposed use is not appropriate for the use of that particular land, because there's a siloed approach at the local level between zoning and planning. And so there was sort of an issue in that case of an overlap between those two worlds. I also think it's noteworthy in that case that the Supreme Court went another step and actually issued a builder's remedy in that case, which is somewhat extraordinary relief, rather than kicking that project back to local review. Basically, the court said you can start construction on your project just based on the decision that we've reached here, because again, that project met all the technical requirements of the ordinance in that instance. I want to shift gears now to talking about DES review. I'm not going to talk too much about the alteration of terrain side of things. Viggo is going to cover that a bit more in a minute, but just know that DES did adopt solar specific regulations for AOT permitting in 2023. And that my understanding is that there's a guidance document that's being drafted right now by DES in consultation with some folks in the industry that will help to clarify some of those AOT rules, but also will help to explain some of the ways in which DES intends to apply its existing wetlands rules to review of solar projects. So unfortunately, DES doesn't have the same solar specific rules for wetlands. My guess is that that's probably going to come at some point, but there's no rulemaking process underway at this point in time. As a consequence of that, solar projects should really be subject to the same review process as any other project that comes before DES for a wetlands approval. I just want to flag a couple of issues that we've seen specifically related to wetlands review with DES. The first one is that, again, we were assisting a client with a proposed solar project. They applied for a standard dredge and fill wetlands permit application. And initially what DES told us was that shading from solar panels needed to be calculated as impact area and factored into the wetlands fee. And after some back and forth with DES on that, and some time has passed since those initial discussions were had, it seems from what I've seen from the guidance, the draft guidance document that's going to be issued, DES has taken a little bit of a different view on that and has recognized that RSA 482A3, which is the wetlands statute in New Hampshire, doesn't specifically require DES to include shading as impact and require a permit for shading, specifically shading impacts. So that doesn't need to be included in the fee calculation or the overall impact area, which is a significant change, and would have had pretty significant repercussions for developers in terms of the overall fee calculation, as well as just the overall calculation of impact area. And then the second piece I just wanted to focus on, which I think is still a little bit up in the air in terms of how it's going to be evaluated by DES going forward, is that under ENVWT 31303, which is housed in the wetlands rules, there's a requirement that DES consider whether or not the proposed project has avoided and minimized impacts to jurisdictional areas to the maximum extent practicable. And to assess that avoidance and minimization, an applicant is required to perform a functions and values assessment and delineate wetlands on the subject property, which is a defined term by DES and includes the parcels of land on which the project will occur or has occurred. And again, I think partly this is a product of a little bit of a square peg round hole, or maybe just a difference in terms of how DES may be looking at regulations versus how a developer may be looking at these regulations. And so when I read that definition, it struck me that that would be in the context of a solar project, for example, where you have leased parcels. The parcels of land on which the project will occur are the leased parcels. But what we have heard from DES is that DES would like wetlands delineations on the entirety of tax map and lot numbers for a project, which may include beyond what a project developer may have in terms of legal rights. If you only have a leased area that goes so far on a project boundary, you may not have those rights to do those delineations. And I think this sets up sort of a twofold issue for project developers. First, just functionally, you may not have those rights and you may have to contract for additional rights to perform those delineations. But then the secondary and probably more problematic piece of this is, even if you are able to obtain those additional land rights to do those delineations, if that portion of the property really isn't available for project development, for whatever reason the underlying landowner may have, it sets up a circumstance where you're providing information to DS that's really not helpful in terms of the avoidance and minimization analysis. And so I think there's kind of two things I would suggest in terms of how to address this. The first is, I think there is a path to seek a waiver from DES. I wouldn't necessarily rely on that in whole, just because the waiver process is somewhat discretionary. It's not a given that you will be granted a waiver. So it's an avenue that you can use, but it's, I guess, not entirely foolproof. And so the second thing I would suggest is sort of before you get to that point, when you're in the process of negotiating with landowners, obviously, first and foremost, make sure you're not obviously intentionally seeking out wet areas more so than maybe uplands. If there's justifiable reasons for why you've leased certain portions of property, maybe it's a interconnection issue, or maybe the town has suggested or required that you have a buffer from certain areas, or whatever the reason may be, I would recommend putting all of that sort of description and explanation into your application up front so that DES can understand why the project area that you've kind of mapped out in your application is avoidant and minimizing impacts to the maximum extent practicable. And it is really sort of the best option that's available given the location where you're proposing your project. So with that, I'll turn it over to Viggo to talk more about the alteration of terrain rules and some recent legislation.
Great. Thank you, Rebecca. As Rebecca said, my name is Viggo Fish. I'm an environmental and energy attorney in McLane Middleton's administrative law practice. For my portion of this program, I'm going to focus primarily on two areas where I think we're seeing some recent movement potentially towards removing or reducing barriers to solar development in New Hampshire. And those two areas relate to alteration of terrain and interconnection. I'm going to try to move through this material relatively quickly so we can leave time for the Q&A. So alteration of terrain, and broadly, DES requires alteration of terrain or AOT permits for any development project that will disturb more than 100,000 square feet of contiguous terrain. That translates to roughly 2.3 acres, except that if any portion of the project's located within the protected shoreline, which is 250 feet from the shoreline, it's 50,000 square feet is a threshold, which is 1.15 acres. So if you consider in the context of solar that a 1 megawatt solar array will typically require around 5 acres of land, under the current AOT framework, which I'm going to discuss, many commercial solar arrays will require an AOT permit from DES. So broadly, the purpose of AOT permitting is to manage stormwater and runoff both during construction and post-development. And just to kind of frame this out, a typical or standard type of AOT permitted project, think of a condominium that's being built or proposed in an area that's partially forested. There may be some moderately steep slopes. And because of that, during construction and post-development, the project's going to change the characteristics of the terrain in a way that's going to alter stormwater flows and likely increase stormwater flows. Obviously, in that circumstance, we want to make sure that stormwater and runoff is managed appropriately. And I just raise this to kind of frame out the context of how solar projects fit into this context of the framework of alteration of terrain permitting. Until recently, DES did not have any rules in place for how solar projects which are inherently quite different from your typical construction development project, would fit into the AOT permitting program. And obviously, for those in the development space, lack of regulatory clarity is generally not helpful when you're trying to design and permit projects. So in 2018, DES first issued some guidance, which was intended to assist applicants or developers in meeting the requirements of the AOT permitting requirements. They were updated in February 2020, and among other things, the guidance explained or tried to explain how developers were to calculate the area of disturbance in determining whether or not they're subject to AOT permitting requirements. And that guidance said defined it as the area encompassed by the solar panels, access roads, and other associated features. So it's somewhat ambiguous in my mind. And following that guidance, more recently, on September 28th, 2023, DES adopted new AOT regulations that apply specifically to solar development. So on the one hand, the rules offer some clarity about what's required of solar developers in seeking AOT permits. But on the other hand, the rules made clear that these were additional requirements on top of all other enforceable AOT requirements applicable to any development project. So some clarity, but also some increased burden, if so to speak. These rules are found ENV-WQ 1511, and I'm not going to go through them in detail. They largely focus on technical engineering and hydrologic requirements. But I did want to highlight one thing, which is the rules do define more clearly the area of disturbance, how you calculate the area of disturbance for determining if you're subject to AOT permitting. And it defines it or establishes it as the area enclosed by a polygon connecting the outer edges of the entire solar array and the area disturbed for access drives and facilities pertinent to the solar plan or the solar array. So on a site plan, if you picture a solar array on a site plan, it encompasses essentially the entire solar array as well as access roads and other disturbed areas. And just again, thinking about solar, it's different from more typical or standard construction projects in that you're not really creating an impervious surface. And after the solar panels are there, there's still vegetation below it. So we're not creating a impervious surface in the same way as a general construction project that's likely going to increase stormwater. So I just raise that to keep in mind, the framework of how solar projects, whether the solar projects really fit into the AOT permitting framework at all. So the legislature had that same question, apparently, and this year they introduced a bill, it's Senate Bill 65, relative to stormwater management for solar arrays. It's currently being considered, and the stated purpose is as follows. It says this bill exempts solar arrays from additional requirements not applicable to other types of development. Requires a permit only if over 100,000 square feet of earth moving or timber harvesting is involved, and also intended to render unenforceable any contradictory administrative rules. So on its face, this bill would seem to limit AOT permitting to projects that are actually going to result in over 100,000 square feet of earth moving or timber harvesting. Currently, the bill as amended requires that DES adopt rules by January 1st, 2026 to establish what's called a permit by notification process for solar projects and related structures with a generating capacity of under 5 megawatts. So focused on commercial scale projects under 5 megawatts. And in the meantime, it directs the Department of Environmental Services to consider waivers from AOT and to not unreasonably withhold approval of such waivers. And Rebecca mentioned opportunity to seek waivers for wetland permitting as well. So to me, this seems like a clear recognition by the legislature that solar projects that don't involve extensive earth moving activities may be well suited for a more streamlined permitting process. And a permit by notification process is essentially that. It doesn't remove the permitting obligation, but it's a much more, provided that your application meets all the requirements, it's a more streamlined process. So again, if passed, this bill has not been adopted yet, but if passed, it would require DES to adopt a permit by notification rulemaking. In closing on AOT, I mentioned there's a public hearing on this bill scheduled for April 7th at the Legislative Office Building at 9 a.m. if anybody has an interest in attending and learning more. So that's alteration of terrain. I'm going to move now to interconnection. And when I think of solar projects or really any renewable energy project, there's two hurdles that project developers face. One is finding a viable site, right? Site selection, location is always incredibly important, can be challenging. But the second is getting interconnection approval. And for most solar projects in New Hampshire, developers need to get interconnection approval from the host electric utilities, so Eversource, Liberty, or Unitil. And before that approval can be made, the utility needs to make a determination of how the project will fit into the grid and really whether any upgrades are needed to accommodate the project, to accommodate a new influx of generation from the project. DOE, New Hampshire Department of Energy, which is a relatively recently established agency, has some rules that apply for interconnection, but primarily for smaller projects, less than 100 kilowatts. Larger arrays are subject to their utility's specific interconnection process. And those processes, those requirements are set forth in each utility's tariff. Recent years, we've seen a sizable uptick in the number of interconnection applications. And I say we, I mean utilities in New Hampshire have seen a sizable uptick in the number of applications they're received. This is largely due to the increase in solar projects and renewable energy projects that are being proposed, which is otherwise a good sign of development. But I think in part due to this uptick in interconnection requests that utilities are receiving, I think many developers would tell you that the interconnection process takes a lot longer, especially for larger projects, than they would desire. And I note this problem isn't unique to New Hampshire. The issue with interconnection is really occurring nationwide. And again, it's fueled in part by the sizable increase in the number of clean energy projects and largely solar projects that are seeking to interconnect to the grid. Again, generally a good thing. We're here talking about solar development, and this is certainly a sign that there's a lot of projects out there looking to get developed. But it does highlight a problem facing the industry, which is really how do we expedite and make the interconnection process more predictable, I would say. Not predictable in terms of outcome, but predictable in terms of timeline. So raises a question, what is New Hampshire doing about this? Well, in 2024, the legislature passed a bill, Senate Bill 391, which was titled An Act Relative to Rulemaking for Setting Uniform Procedures for Distributed Energy Resources, proposed for interconnection to the electrical infrastructure. The stated goal was to set cost-effective, timely, and predictable processes for customer generators. That's a term, customer generators is a term that's defined in New Hampshire's net metering statute, wishing to interconnect to the state's electric grid. And toward that objective, it directs the Department of Energy to open a rulemaking docket for the purpose of setting, this is a quote, setting uniform procedures for distributed energy resources that are proposed for interconnection to the electrical infrastructure of New Hampshire's investor-owned utilities. In response, DOT opened a rulemaking docket. The notice of order of notice was issued in September of last year, September 24th, 2024. It is an open docket now. There's a lot of information on DOE's rulemaking page. You can read comments that have been submitted by stakeholders. You can read the status reports of where they are, some of which I'm going to discuss now. But essentially, DOE has commissioned a stakeholder process to develop draft proposed interconnection rules. These stakeholders have met over a series of technical sessions to discuss and ultimately propose to DOE of a recommended or proposed rulemaking framework. These stakeholders are largely made up of electric utilities and renewable energy developers, kind of the parties that you would want to be involved in advising on a rulemaking process for interconnection. Those are the parties that are typically involved in that process, as well as other interested organizations throughout the state. As a brief summary of how the rules are being developed, the stakeholders have proposed using the existing interconnection rules and procedures that are in force in Massachusetts as a starting point in crafting New Hampshire specific rules in support of this. And again, a lot of this information is on the rulemaking docket if you want to look, but they cited broad familiarity with Massachusetts rules, which have been in force for some time, familiar by the utilities, by renewable energy developers in the region, and the stated alignment of Massachusetts rules with national best practices. So it seems that DOE has effectively accepted this approach, and they asked the stakeholder group to review the Massachusetts rules and to use that to craft proposed draft New Hampshire rules. On March 17th, some members of the stakeholder group provided an update to DOE. That update is available on the website I mentioned. And on March 20th, so a couple weeks ago, DOE provided an update to the legislature that targets a deadline to file draft rules of October 1st of this year. So not too far in the future. And obviously, once draft rules are filed, they're subject to comment, and there's opportunity to be involved in that rulemaking process. Final rules would come out sometime thereafter. So we may have final rules towards the end of this year, maybe it gets kicked into 2026. One issue that I wanted to highlight that's emerged in this rulemaking docket is that we should keep an eye out for is a determination or a decision of which solar projects the rules would apply to. The Department of Energy is taking the position that their jurisdiction, their rulemaking authority, is limited to projects that are 5 megawatts or less, and they point to the jurisdictional thresholds in the net metering rules that establish a 5 megawatt cap for net metered projects for municipalities. Any other entity that's not a non-municipal entity is limited to a 1 megawatt cap. Some stakeholders argue that the rules should be for projects in excess of 5 megawatts. So just something to keep an eye out as draft rules are issued is whether the rules are limited in terms of the capacity of the project. So we have some time left. I'm going to stop now so that we can use the rest of the time for Q&A if everybody wants to come back on.
Thank you so much, everyone. Fascinating, and we have a lot of questions from the audience to dive into here, which is always an indication that they were engrossed by what you were talking about. So thank you. Let's dive right in. Some of these, I'm going to pick a couple of questions that were answered offline first, but that we do want to surface so everybody gets the benefit of hearing the answers here. Question is, I'm interested to hear the presenters address solar farm and abutter property value concerns in New Hampshire. What precedents and resources are you aware of for New Hampshire to support development?
I can start with that, and Rebecca and Vigo can weigh in. So I did address this a little bit offline. At the site evaluation committee, property values are looked at with every project that goes through there. And as I mentioned, there's one in particular, a solar project that did go through the SEC. And so that issue was looked at for that project. The expert in that proceeding who looked at it was a guy named Matt Magnuson, who does economic consulting work and has appeared at the SEC a number of times. Matt did a literature review in that case of the effects of these projects on property values. And his conclusion in that docket was that there is no effect. And that's consistent with what we've understood elsewhere, but also seen with some of these other larger projects, which is it's counterintuitive that when you build a transmission line or a solar farm or something like that, people think it's going to have an adverse effect on property values, but the evidence frequently suggests it doesn't. In fact, there was a large study done by the National Renewable Energy Lab 6 or 7 years ago, and I think repeated, that looked at hundreds of thousands of property value transactions around the country in relation to utility scale wind farms, and found little to no effect. So there's a lot out there for people who are interested in digging into it a little bit.
Yeah, and I just would expand on that a little bit. In that same docket, there were two specific studies that came out in 2018 that specifically dealt with utility scale solar projects and the impact on real estate values. So you might want to look at those specifically from 2018. But what Matt Magnuson also did in that docket was look at a much larger breadth of literature that's been done with respect to wind facilities and the effect on real estate values. And I mean, his conclusion, and this seems sort of like a logical conclusion to me, is that in the context of wind, you're talking about likely much more probability of impact, right? Because these things are large, you can see them from much more expansive swaths of land, as opposed to solar, which is lower lying, so you don't have those aesthetic impacts. And even in the context of wind, what we've seen consistently is that there really just aren't these effects on property values.
Okay, so I wanted to piggyback a little bit on that question and thinking back to something that you had talked about, Rebecca, which was a situation in which if the developer were meeting the requirements as spelled out, that would in effect supersede a local board's maybe just preference not to have the project. And that got me thinking, what besides this property value question, what are some other common misconceptions that towns have that shape those preferences about solar projects? And I guess open that question up to everyone.
Yeah, so I'll start. I think, you know, in the context of the case that I was talking about that went to the Supreme Court, I think the concern was sort of a twofold piece. One was on sort of aesthetics generally, which I think is a common concern at the municipal level. And then the second piece, which has to do more with zoning, is whether or not that's an appropriate use of a particular piece of property within a town. And so that's where there's a little bit of I think a challenge at the municipal level between how you parse what is a zoning decision as opposed to what the planning board has the purview to review. And I think sometimes these things go hand in hand, but sometimes because you're at the planning board, usually at the final stages after you received all your variances from the zoning board, I think what happened in that case was they tried to kind of do an overlay and say, under our purpose section for zoning, you know, we try to promote aesthetics, we try to promote all these things, and they tried to fit in that maybe this isn't an appropriate use for this location. And that was something that the court really addressed to say, that's not really an appropriate use of these regulations.
Okay, and anybody else want to comment on common misconceptions that municipalities or even residents may have about the impact of solar on their community? All right,
I mean,
well,
one other piece I would just throw out, because I think there was a question about this too, is I know there's some concern about effective runoff from and stormwater related issues associated with solar projects, because you are talking about, in most cases, sort of a significant amount of land disturbance. And I would say that I think the AOT rules that were adopted in 2023 do a pretty good job of making sure that those types of issues are comprehensively addressed in the permitting process. So, and any town review process is going to be coupled with that state DES review process. Similarly, if you're at the SCC, if you're above that threshold or you seek discretionary jurisdiction, you're still going to have to go to DES for that AOT permit or wetlands permit. So either way, I think that the AOT piece kind of covers those concerns about runoff and stormwater.
Yeah, and I would just to pick up on that, the AO2 rules are comprehensive. They require engineering analysis and calculations of stormwater flow and sheet flow coming off the panels, for example. I wanted to note one thing that's in the rules, which is an exception from the requirement to do hydrologic analysis. The rules provide that solar developers aren't required to do the hydrologic analysis you typically would for projects where slopes are less than 5% or less rather, and where the existing ground cover is open space, pasture, or grassland, and where gravel or paved access impervious surfaces account for less than 2% of the area of disturbance. So Rebecca's exactly right. There's a lot of really specific requirements for managing stormwater, controlling erosion during construction, etc. But I wanted to note that the currently existing AOT rules applicable to solar panels carve out an exception where the site itself is such that you wouldn't expect significant water flowing, runoff, or stormwater post construction.
okay. Also related to AOT, a question from the audience would be curious to know if you folks have been following SB 65 regarding AOT.
Yeah, so I touched on that briefly, and as I mentioned, it's kind of hard to predict exactly what the legislature is going to do. But my understanding is there was amendment. My view of the bill is as proposed. It's been amended, and it's been amended. I think as initially, I'm trying to recall memory now, but as initially proposed, it was essentially an exemption from any permitting on AOT, and it's been amended in the legislature to establish a permit by notification process. So if adopted in its current form, obviously it's still subject to further amendment. I believe it's it's still in committee, but it would establish a permit by notification process. And what that process is it exists in wetland permitting, for example, and the rules would set out here's the specific requirements you have to meet in your application. If we deem your application complete and you check all the boxes, you get a permit. And so it's an expedited, more streamlined process with kind of clear goalposts about what's required to be submitted. So that if SB 65 is adopted in its current form, we would expect to see further rulemaking by DES in early 2026, and likely that rulemaking would replace the rules that I just talked about today.
Okay. Another question from the audience. We have commercial sites that have a lot of trees near the roof or ground that are owned by the site owner. Shade reduces generation and capacity. How difficult is it to get permission to trim trees in this situation?
I don't know that we've had this issue come up. I think assuming that you're talking about an abutting property owner as opposed to a property owner who you're engaged in sort of lease agreements with, I think that's something I would definitely recommend you look into before as part of the initial development phase to make sure that that doesn't become an issue. I think, there's statutes in New Hampshire that talk about those tree trimming and tree removal rights of property owners. So I think it would definitely be something you'd need to contract with or negotiate with a budding property owner. It's not something that you could necessarily do as of right. If say the limbs went over onto the property that you were leasing, you still would need to come to an agreement with the property owner beforehand on that issue, I think.
Okay. Question from somebody who works in environmental consulting. I'm curious, when working with solar developers in New Hampshire, what kinds of environmental challenges most often complicate the permitting process? Are there issues beyond wetlands and wildlife, like stormwater, subsurface conditions, or legacy site impacts that you see coming up more often these days?
Rebecca, you want to take that one on?
Yeah, I mean, I think from our experience, the biggest ones are the wetlands related issues and AOT. I mean, I think AOT is probably, in terms of impact area, again, you're talking about just typically it's a larger swath of land. So the permit process is fairly robust there. I think on the wetland side, the challenges that you have, again, kind of going back to what I presented on, is because there's no specific rules for solar, it tends to be, the wetlands process tends to be a little bit of a slower review process, with lots of RFMI requests for more information going back and forth with DES to try to nail down these details that maybe at first blush seem like they don't necessarily apply, or they apply in a certain circumstance but shouldn't apply to a solar project. But maybe DES is looking at it in a different way, and that gets flushed out through the permit process, which for every request for more information that's issued by DES, you basically start a new clock again. So, you have a 60-day review process, but then if they issue that request for more information, you're then going up 30 days for you to respond, additional 30 days for them to issue their decision. So that timeline just keeps getting extended out. And for us, at least, that's what we've experienced to be the biggest issue, because obviously all these projects have a timeline. And if that gets hung up sort of in that back and forth with DES, that can be a problem for development. So those are the issues that we've mostly seen.
Okay. Speaking of timelines, we have a question from the audience. What is the typical time to obtain permits? Commercial scale under 500 kilowatts, solar farms greater than 1 megawatt.
Do you want to start, Barry?
Well, I was going to start. I mean, when you say greater than a megawatt, the sky is the limit, right? If you end up at the SEC, from the time you submit your application until you get a decision, you can expect something in the neighborhood of 14 months, give or take. And it can take a chunk of time to get your application prepared. It depends on the complexity of the project, but 6 months to a year to prepare the application, or even more, is not unusual. If you're not at the SEC, it starts to vary much more dramatically, because now you're trying to line up state permits, local approvals, and so forth. And maybe I'll let Rebecca and Viggo talk to that piece.
Sure. So, I mean, just on, if you're talking about local review process, there are statutory requirements for once you've submitted, say, your variance application, how long, and I honestly can't remember, I think it's a 60-day clock under the statute for them to review and approve or deny your variance application. And then similarly, there's a statutorily prescribed time frame for site plan review. And within that same time period, you can simultaneously be seeking your approvals through DES. So this isn't like you finish with your local review process and then you move on to the state permitting. It's kind of one and the same. So from a timing perspective, you can save time there. I think generally speaking, what we usually tell people is that at the local, through the local process, it's, if you're going through site plan review and you need some sort of a variance relief, it's typically like 3 to 4 months time period for that review process, assuming you don't have, a lot of opposition or people who are asking for additional information to be produced as part of that process. And then similarly, on the DES side, I mentioned, how these timeframes can be expanded. But typically, in theory, at least, you should be operating within sort of that same window of time in terms of getting those approvals if you're at the local level and you're going through with your state permits.
Yeah, and I think on the DES side, I mean, Rebecca mentioned kind of some of the variables that come, but I think it's important to press the point that the more work you do, the more complete your application is. AOT in particular, as I mentioned, requires robust technical engineering calculations. So it just bears emphasizing that the more complete your application is, the more clear it is, the more final your design is of the solar project, the more likely you are to have a more predictable path going through the permitting process. Because what happens with DES is they have questions about your application. Obviously, you've checked all the boxes, but they have questions, they want clarifications, and they issue what's called a request for more information, as Rebecca mentioned. Usually you'll have 30 days or so to respond, and then they'll have 30 days to respond, and maybe they have more questions. So I guess the point I'm making is that the more complete your application is, the more complete the information you're providing, the more likely you are to have a more predictable path forward. And to that same on that same point, we've seen projects that get changed. You file your application, then there's a change in design. That can cause delays, and that applies to interconnection as well. I think one of the issues that come up with utilities managing interconnection requests is they file a request and then there's a change to the project, and so the process kind of starts over. So the more homework you can do, the more complete your project design is at the outset of the permitting stage, the more likely you are to have a smoother permitting process.
Yeah, I think we've probably got time for one more. We have a question from the audience. Curious if the presenters have any experience with the payment in lieu of taxes or pilot program that are typical of commercial solar projects, and how New Hampshire municipalities approach these agreements.
Yeah, we're kind of at the end here, so there's not a lot of an opportunity to jump into this. The short answer is yes, we have been involved with them before. For folks who don't know, it's basically an agreed upon structure where the renewable energy project and the host community come up with an approach for how property taxes are going to be paid going into the future, rather than deal with that on a year-by-year, case-by-case basis, which can, in a lot of circumstances with these kinds of projects, not just solar, result in disputes. And so our experience has been, we're involved in one, for example, with the Antrim Wind project. Our experience with those has been that both sides like them a lot. Developers like them because they provide predictability, which is what they're really hungry for. Towns like them as well because of the predictability, the avoidance of any arguments about those types of issues. They can be complicated. There's authority legislatively to do those kinds of things. But I think that's probably about as much as can be said about it at this point.
Yeah,
Great.
really quickly, the only thing I would add is that we also, in the context of the solar project that we were assisting with, they also have a pilot agreement with the municipality, and that was something I think that the town really appreciated the opportunity to enter into that agreement, like Barry said. So even in the context of a solar project, that's also been well received by municipalities.
All right. Well, and that brings us to the hour. Thank you so much, Rebecca, Barry, and Viggo. Thank you to McLane Middleton for sponsoring today's webinar. And thank you all out there who joined us today. We appreciated your engagement and your questions. And thank you so much for being here. Thank you all. Have a great rest of the day.
Thanks.